Hi, thanks for joining us for this Ametros educational webinar. My name is Shawn Deane. I'm General Counsel with Ametros, and I'm very excited and glad to be having a conversation with Parashar B. Patel of the Patel Memo. This is something different than we've done, and we're really excited to have Parashar here. And if you're a student of Medicare Setasides or Medicare Secondary Payer Compliance like I am, I've been in and around the industry for over a decade now, you'll know that this memo is probably the most important document in the area of Medicare Setasides. It really set the groundwork, laid the foundation for MSAs as we know it. And typically on these types of educational webinars, you know, myself or colleagues will be speaking about professional administration of MSAs. But this will be a little bit different. We're going to be having Parashar here, and we'll walk through some of the educational components around Medicare Secondary Payer Compliance and Medicare Setasides, but we're also going to dig deeper into the Patel Memo and get kind of Parashar's take at what was happening at the agency at that time and what might have led up to these events. I should say too, Parashar's no longer with CMS, and you know, any analysis or feedback or insight will just be his personal opinion, my personal opinion. It's certainly not the policy guidance of the agency, and nothing here will be can be deemed legal advice. This is just two people having a fireside chat about a very important memo. And for me, frankly, this is kind of a fanboy moment for me, having been in the industry for so long. I can't thank Parashar enough. It's a real treat to have him here. So before we get into it, this was kind of my introduction. We're gonna be going through some of the kind of requisite MSP background stuff for folks who maybe have never heard of a Medicare set aside and we're just excited to see this webinar. So I'll go through some of that. And then we'll talk a little bit about kind of what led up to pre-Patel memo, what led up to the codification via Mr. Patel's memo. And then we'll dig into the memo itself. And then we'll kind of look through and see what happened with the evolution of Medicare Setasides too, and maybe get Parashar's take and sort of reaction and his thoughts of, you know, how this industry really exploded and the adoption of Medicare Setasides. So before I go any further, Mr. Patel, thank you so much for being here. I think a lot of people probably want to know who you are and want to know a little bit about your education and your background and kind of where you've come from. So, Mr. Patel.
Thank you very much, Shawn. I appreciate it, and I'm glad to be here for the webinar. When you called, to be honest with you, I had a hard time kind of remembering what the memo was, and then you sent me the link, and I kind of old memories started coming back. As you said, it was nearly 20 years ago, and I was at CMS at the time. Currently, I'm at a company called ViewRay. We make the world's first MR-guided radiation therapy linear accelerator. Basically lets radiation oncologists treat cancer much more quickly, more effectively in terms of bringing patients in to the hospital less often, improving quality of life, et cetera. And so it's a small company, less than 250 folks. I lead our government affairs and market access, so payment policy, health economics, et cetera. Prior to that, I spent about 16 years at Boston Scientific up here in Boston in a similar global role around health economics reimbursement, leading the team there. And then immediately prior to that was when I was at CMS. I was there for about 5 years, late 90s, early 2000s, and previously spent another 4 or 5 years in different health policy roles in and around Washington, D.C.
Thanks so much, Parashar. I think, you know, folks probably have misconceptions about, you know, who you were, and I know at the time there wasn't the setup where there was an actual MSP, Medicare Secondary Payer division within the Office of Financial Management. So it'll be interesting to, when we get back into the memo, and I'm with you, I don't even remember what I had for breakfast. So to call upon you nearly 20 years later to recall, you know, a singular memo is difficult, but we appreciate you, you know, joining along to kind of help us walk through this journey that was, you know, the epicenter of Medicare Setasides. So with that, we're going to go ahead and get into Medicare Secondary Payer background to give kind of some people who don't have knowledge about this some footing. And I'll welcome you, Parashar, as I go through some of this material. To certainly come in with any color commentary you have as well, leading up to our talk on Medicare Setasides. So before we can really get into the nuts and bolts of Medicare Set-Asides and even Medicare Secondary Payer Compliance, we kind of have to look and figure out, okay, what is Medicare? And we'll sort of take a journey through time leading up to Mr. Patel's memo, and all the way back in 1965 with the enactment of the Social Security Act, which effectively created Medicare with LBJ. And if you look at Medicare, you have a couple traditional components or traditional Medicare that comprise Part A, which is hospital, and if you're otherwise eligible, you don't typically pay a premium for that. And B, you do pay a premium. That's outpatient treatment that you receive. We're currently hovering around 40 million members for Part A and Part B Medicare beneficiaries. And when you're looking at entitlement, typically when you think of this, you think of by age. So when you reach age 65, so long as you've paid into the Medicare program, you can become entitled to Medicare. That comprises the bulk of the eligible enrollees within the Medicare program, right around 84%. But you can also have disabled individuals that can otherwise qualify for Medicare, around 16%, and that can include individuals who have received 24 consecutive months of Social Security disability insurance, or folks who have end-stage renal disease and are undergoing dialysis, as well as individuals who have ALS or Lou Gehrig's disease. Then you have sort of this other component that was brought in 1997, and this is Medicare Part C. It was initially called Medicare HMO, but it's otherwise referred to as Medicare Advantage, and enrollment is increasing pretty widely, almost up around 20 million enrollees. And this is essentially when a Part A and B enrollee decides to opt out and pay an additional premium and have their Medicare benefits expanded and administered by private companies such as Humana and Aetna and the like. Then you have Part D, and Part D benefits comprise prescription drug coverage, and that was enacted in 2003. So this is the sort of the overview of what Medicare enrollment is. And then you fast forward way from 1965 all the way up to 1980, when the federal government started looking at an eroding Medicare trust fund. People started living longer thanks to the advancements in medical science. As Parashar indicated, those are some of the companies that he's involved with. But there was also instances where the government was looking at a particular study by the OIG that saw that Medicare beneficiaries were involved in claims for bodily injury, such as automobile accidents, workers' compensation instances. And it should be noted that with the passage of the Social Security Act, that workers' compensation has always been primary to Medicare. That is, Medicare has been secondary to workers' compensation since Medicare's inception. But what the government decided to do was enact federal law that makes Medicare secondary to all forms of insurance, any type of self-insurance, liability insurance, auto no-fault, workers' compensation, even in group health plan instances. And so with 1980, there was the passage of the Medicare Secondary Payer Act. You can see the statute cited there with the applicable regulations. And with its passage, it ensured that Medicare would be secondary to any instance where there was a Medicare beneficiary who had claimed bodily injuries and there was responsibility of an applicable primary payer, being an insurance carrier or self-insured. There was various instances where that statute's evolved over the years. They added self-insurance, they added no fault. So it's been amended several times. It's important to note here too, so you have the statutory authority, which is sort of the law of the land. Then you have the regulations, which are administrative rules, but you also have policy, and this is what will bring us into when we're talking about Mr. Patel's memo. So you have policy memoranda that were issued by CMS, and then later you have instances of reference guides like the Workers' Compensation Medicare Set Aside Reference Guide. You have the Section 111 User Guide, as well. But at the end of the day, this whole concept of Medicare Secondary Payer is this system is in place through statutory, regulatory policy, case law, et cetera, to ensure that there is not a shift over to the Medicare trust. So it's designed to protect an otherwise eroding Medicare trust fund. Okay, and there's also some fairly important MSP concepts that have to be understood with respect to how Medicare Secondary Payer operates in order to understand what the compliance components are, and certainly even leading up to kind of the more advanced aspects of understanding how Medicare Setasides operate and work. And the first and probably the most important is the #1 mandate from the statute, which essentially says Medicare shouldn't make any payment when there's any primary payer responsibility. And this concept's known to us as coordination of benefits. So when there is a Medicare Secondary Payer event, i.e. a Medicare beneficiary who has claimed injuries and there's a responsible insurance carrier or self-insured, if there is treatment sought at a provider and there's MSP responsibility, Medicare should effectively deny treatment. The second is, and we know how this works in the real world, even though Medicare should be denying treatment, we know they in fact do make payment. So in the event that an injured claimant goes and seeks treatment and has a claim against a carrier or self-insured where there's responsibility and Medicare happens to make a payment, they only make that payment on the condition that they're going to be reimbursed. And we know this concept is Medicare conditional payments, and we'll go through sort of the ins and outs and conditional payments in a minute. The next important concept brings us right to Mr. Patel's memo. So in certain workers' compensation settlements where there's a resolution of medical expenses and there's a full and final settlement, there's a charge by CMS that indicates that funds have to be set aside in contemplation for future or post-settlement Medicare covered items and services. And those funds that are set aside can only be utilized for those applicable expenses. And that is the concept we know is Medicare Setasides. And last but not least is, how the heck does Medicare find out if there is a Medicare Secondary Payer event? Well, prior to Section 111 mandatory insurer reporting, it was kind of Scout's honor. There's a couple regulations that require notification to Medicare, but it was through means of written correspondence or telephonic communication to a coordination of benefits entity that would require it. But in 2007, this was changed with mandatory insurer reporting, which we're going to get into. And sort of looking at instances on a continuum and kind of bringing it all together. In the event that a person sustains a bodily injury and they happen to be entitled to Medicare, if that person goes and has a claim against an applicable primary payer and they seek treatment, again, what should occur is that Medicare should bill the primary payer and should deny payment for that particular claim. They shouldn't make a payment. But as we know in the real world, what happens when an individual's in an automobile accident that happens to be a Medicare beneficiary that's taken to the ER, it's not like Medicare is not going to pay the claim. They're going to pay that claim on the condition of reimbursement and recovery. And then lastly, if there happens to be a settlement and there's a charge by CMS where Medicare's interests need to be protected, and this is the concept we're going to get into heavily when we talk about Mr. Patel's memo around Medicare Setasides. And now in turn, we're going to go through each of the Medicare Secondary Payer Compliance Components, and first is Section 111. And one of the largest changes to the Medicare Secondary Payer Act was the incorporation of the Medicare Medicaid S-CHIP Extension Act of 07 that required, among other things, the fact that insurance carriers and self-insureds, known in the parlance as responsible reporting entities, have to report electronic information over to Medicare about bodily injury claims involving Medicare beneficiaries. So if there's a workers' compensation injury or an automobile accident or a slip and fall in a commercial space where there's a claim brought and that's a Medicare beneficiary, Medicare requires notification of that electronically. So now with the amendment of the MSP Act, with this process, Medicare has the ability to determine whether or not they should be properly coordinating benefits or making payment or seeking recovery. And there's several processes that are involved with this. One's the query process to determine eligibility. So this is a way that electronically primary payers can sort of ping Medicare, for lack of a better term, to determine if they have a claimant that's involved in an incident. And then when there's acceptance of that claim, especially in workers' compensation, they report over ongoing responsibility for medicals. And then when that ceases, they report over an event called ongoing responsibility for medicals termination, or ORM term. And then when there's a full and final settlement involved, there's this instance called a total payment obligation to claimant, or a TPOC event. At the end of the day, this electronic reporting requirement is in place to ensure Medicare has notification so they can properly coordinate benefits and seek recovery. And as a collateral instance, it also would alert them to the fact if a Medicare set aside should have been incorporated into a settlement. Of note here, it's the only Medicare secondary payer compliance component that involves a $1,000 per day civil money penalty for noncompliance. The next component relates to conditional payment recovery, and these are instances where Medicare really shouldn't have made a payment in the first instance, but they do, and they make payment on the condition that they'll be reimbursed for the payments that they made. And the risk is pretty significant to pretty much all parties involved in a claim. Medicare has a direct recovery action right back to the primary payer. They can also recover against the beneficiary and their attorney. And if the parties fail to reimburse Medicare for a debt, they can charge interest against that debt and also refer it over to the U.S. Department of Treasury for further collections. And last but not least, if the debt continues to go unpaid, they can refer it to the Department of Justice for a federal court lawsuit. Just a note with respect to workers' compensation, because that's what we're talking about primarily with Mr. Patel's memo. Of note, work comp recovery can occur prior to any settlement. So during the pendency of a claim, if there was payment that was made by Medicare that should have been the responsibility of the carrier or employer, Medicare can come back and recover it. And finally, the last compliance component is exactly why you're probably here today watching this webinar to talk about Mr. Patel's memo, is Medicare Setasides. And we're going to cover this concept in much greater detail. But when you have a full and final or a lump sum type workers' compensation resolution that encompasses medical expenses, Medicare has a policy requirement where you take their interest into consideration and set aside funds to cover post-settlement Medicare covered items and services for the lifetime of that individual that are related to the industrial injury that are otherwise covered by Medicare. And CMS, through various memos, including the Patel memo and its progeny and the Work Comp MSA reference guide, have indicated that if Medicare's interests are not adequately considered, they can do things like refusing to pay for treatment going forward, not paying for otherwise eligible medical expenses. They can totally disregard the settlement, as we'll see in the applicable regulation. And they also indicate they could have some sort of recovery or even potential subrogation. Now we're going to be talking about sort of the events leading up to the Patel memo. So kind of a history lesson around Medicare set-asides. And I personally don't stand here today and say that I'm the most authoritative figure. There's other individuals who've been in this industry much longer than myself, and I've been a student and an MSP practitioner of it, and have certainly done a little bit of research leading up to this webinar and have followed it for many years. But folks who are scholars in this area know that everything is related to Medicare set-asides is sort of foundationally based. Well, as we know, it's based on the Patel memo, but it really comes from regulatory authority, and one regulation in particular, which is 42 CFR 411.46. And in preparation for this, Mr. Patel pointed out correctly that this actually, I thought it was a much newer regulation, but it actually appeared in the Federal Register way back in October of 1989. And interestingly, it's under the subpart, it's obviously an MSP reg, but it's under the subpart, limitations on Medicare payment for services covered under workers' compensation. So it's specific to workers' compensation. And what's this regulation outline? Well, first it breaks down the difference between the two types of workers' compensation settlements, commutation of benefits versus compromise. And in sum, a commutation of benefits case is an instance where there was an accepted workers' compensation claim and there was responsibility on the part of the carrier to pay for medicals, and there was a subsequent lump sum payment or buyout of the medical component of that claim that would otherwise relieve the carrier going forward after the settlement, versus a compromise claim. A compromise claim is an instance where there is either a denied or controverted case where either in fact or in law, the carrier or employer had a basis to dispute that claim, and there's some sort of contested aspect of that, and there's not necessarily a payment of medical expenses, just a payment to the individual claimant to compromise the claim without acceptance of any liability, much more like a liability, traditional general liability case. What's interesting here too in the regulation, and I'll read the text because it's important if to sort of understand where CMS is coming from and where the Patel Memo's underpinnings have in this is this specifically. So if a lump sum compensation award stipulates that the amount paid is intended to compensate the individual for all future medical expenses required because of this work-related injury, Medicare payments for such services are going to be excluded until the expenses related to the injury equal the amount of the lump sum payment. So that says essentially that there's potential exposure there up to the total amount of the lump sum payment, and meds need to be spent down in that amount before Medicare is going to come in and pay for anything. And that in essence is the basis of the procedure to set aside funds and identify funds that would be related to that individual's post-settlement treatment needs that are otherwise covered by Medicare. And here's sort of the teeth to it. It further says that if a settlement appears to represent an attempt to shift to Medicare the responsibility for payment of medical expenses for the treatment of the work-related condition, the settlement will not even be recognized. Now, that's a pretty intense statement there. I don't know that it's ever been necessarily challenged, but those two clauses there in effect set the stage for the policy that would later come out of the Patel Memo, and frankly the practice that even started before then of setting aside funds. Now, obviously Medicare all the way back in 1989 was looking at this this instance where there was work comp settlements that the carrier was responsible for, and the claimant would receive a lump sum of money and immediately start treating with Medicare. And the practical effect here was to ensure that those settlement funds were being utilized to pay for Medicare covered items and expenses so as to avoid a cost shift back to the taxpayers, back to the Medicare Trust Fund. Now, in the mid-90s, and this is sort of an oral history as I've been told by folks who've been around. In the mid-90s, some of the first Medicare set-aside trusts were established, and I did a little bit of research and found a couple pieces that can still be found online. And the first piece is entitled "Protecting the Disabled Individual Through the Use of Medicare Set-Aside Trusts." It looks like, based upon the date it first appeared around September of '99. I think it was also republished several times too, but the article spent quite a bit of time discussing the particular regulation that I spoke to on the previous slide. And in that article, there's an indication, an assertion that the author had worked to create the first Medicare set-aside trust in a catastrophic case back in 1995. So it was a practice that was occurring in the mid-90s. And there's also another piece by the same author that looks like it appeared in the Florida Bar Journal in May 2000, discussing the use of Medicare set-aside trusts and work comp settlements. And there's an actual quote where CMS, and back then they were called the Healthcare Finance Administration, was quoted as saying there was an ongoing investigation of instances where, quote, Medicare's interest was not considered and protected. And those two words, Medicare's interest considered or protected, are sort of the hallmarks that go with it's language that's in the Patel Memo. It's language that's still to this day cited on CMS's website, on the WCMSA website. It's language that's within the WCMSA reference guide. So there was some groundwork here, and there was instances within these articles that talked about early informal review by CMS through some of the regional offices. It doesn't appear as it was, obviously it wasn't codified until the Patel Memos issuance, but needless to say, these events leading up to the Patel Memo, by the late 90s, there was definitely increased adoption in workers' compensation settlements that folks were doing these Medicare set-asides. There were some initial thought leaders in this space and practitioners, attorneys and nurse allocators really paving the way for a cottage industry that really blossomed into what it is today, with the wide acceptance of this as a practice that was codified via policy. And with that, we're coming to Mr. Patel, to the memo that bears your namesake, and I'll kind of walk through substantively of what I see in the memo, and then I'll kind of turn it over to you to talk about what was going on at CMS at the time, and any sort of analysis that you have of what occurred. But so as you can see, this memo issued July 23rd of 2001, and I wish we were talking about this a year from now on the 20th anniversary, but I suppose it's an appropriate time as any. But this, folks who are joining us, this is the first instance where the Centers for Medicare and Medicaid Services codified any formalized policy around MSA. So this memo is the first written documentation for Medicare that outlined this process. And what's important here too, as I was going through the memo, I can't even tell you how many times I've read it in the last 11 years or cited it. Much of the framework, the foundational framework, still exists to this day that was set up, and I'll walk through it. Most of the beginning of the memo discusses this regulatory authority at 42 CFR 411-46. It goes through and distinguishes again these commutation versus compromise settlements. But what's of note is the Q&A portion, and there were many memos that were issued after the Patel Memo. Obviously, this is the first one, but the Q&A portion of this really goes through much of the MSA process and much of the theoretical foundation that we know exists today for it. So, for example, it provides the authority to provide a written opinion of the sufficiency of the MSA prior to an individual becoming entitled to Medicare. In a few slides, when I talk about the current review thresholds, that review threshold still exists. So it established it when an individual has reasonable expectation and a settlement exceeds 250 grand. This is interesting that they went through it and said, we get it that someone might not be entitled to Medicare yet, but they have a reasonable expectation that they will. And this, Mr. Patel, your memo indicated that CMS has the authority to provide a written opinion on the sufficiency of an MSA, even though when an individual is not yet entitled. It did have a threshold for review for a Medicare beneficiary, regardless of the settlement amount. Obviously, that changed throughout the years. There was an initial low dollar threshold of 10,000, and then it went up to an excess of 25. But it also provided, interestingly, an established process for monitoring post-settlement. And it doesn't occur this way today, but there was an indication there of CMS monitoring these Medicare set-asides to ensure that Medicare wouldn't pay for items and services and that would come out of the MSA. And then it also talked about recognition that there could be a temporary depletion in an annuitized MSA. It set up this really foundational component to MSAs that it's really there to cover for lifetime medicals, not for a limited period of time. You could tell there was some back and forth in some of the early questioning and writings around MSAs that, should it cover for 5 years? Should it only cover for a limited amount of time? And the Patel Memo outlined, no, an MSA is there for post-settlement Medicare covered items and services related to the injury for the entire lifespan of that individual. And then it also direct payment at the work comp fee schedule when applicable, and that's still a rule there. So before I go into it anymore, Mr. Patel, what can you tell us? What was going on back in 2001? First of all, kind of what was your role? Is I guess you were Deputy Director of Purchasing and Policy at CMS.
So, Shawn, thank you very much. So, back then I was the Deputy Director of what I think it's still called the Hospital and Ambulatory Payment Group, which was the group that was responsible for payment policy for virtually all of Medicare's acute care payment systems. So inpatient hospital, outpatient hospital services, physician fee schedule, et cetera. But we also had a group that was responsible for a few other policy areas, including workers' compensation. And I should note a couple things. First of all, I'll just reiterate, everything I say here is my own personal opinion, my own personal recollections, because 20 years ago it was a long time, and clearly I'm not at the agency, so I'm not in any position to opine about what the official agency's position was at the time. I don't have the records or anything else to go back and do that research. So part of this is, a lot of this is from memory and a little bit of an internet search. That's sort of one thing. The other thing is, I think, Shawn, I was surprised as anyone when you called me and said, the Patel Memo. And while it's been known that way, I do want to make it very clear that as with a lot of things at large organizations, but particularly at CMS, it's a team effort and it's a team sport. And so, Fred Graybow, I think, is the analyst that's listed in the memo. Certainly, he would have been the primary author and had a heavy hand in it. And there was obviously his manager and myself ultimately reviewed it and went out under my signature. But call it the Patel Memo, I think, gives me personally a lot more credit than it's due. To be very clear, a lot of folks involved in that. I'm sure there were folks in other parts of the agency, including the regional offices to which the memos actually addressed. But as after Shawn, you and I talked the first time, I started doing a little bit of digging online, et cetera, and memory sort of started jogging. One thing I think was happening around the time there were a couple general accounting office, GAO reports. I guess it's called the General Accountability Office now, but GAO reports around Medicare error rates in terms of, is Medicare paying claims appropriately or not? And in one of them, and I can't remember whether it was the one that came out in the spring of 2001 or the one that came out prior, they specifically talked, I think, about workers' compensation and Medicare not being fully aware when a new beneficiary becomes eligible, whether that beneficiary had a settlement or not. And I suspect I know because memory jogged me, towards the last couple of years of the Clinton administration, Nancy Andaparlo was the administrator, there was some activity around making sure Medicare was paying claims properly, and there was all sorts of agency standards set up to monitor that. And so one of the efforts that was made, I think, was to try to identify beneficiaries that had these types of settlements, make sure that we were looking at the settlements before paying Medicare. So I suspect that's what was swirling around for the last year and a half before the memo was issued. And then ultimately, because this was administered, at least at the time, through the regional offices, the memos, I think, probably an attempt to answer questions from the regional offices to bring some consistency to how one regional office would be treating it versus another. So as much for the regional offices as it was, I guess for the external community as well. I think that's kind of what led up to the memo itself. And frankly, if I had known that it would become what it has become in terms of what it's launched, I probably would have taken more careful notes in terms of what we were doing, et cetera, to jog my memory.
Now, I'm sure you had a lot on your plate. I guess too, just so folks know, what were some of the other responsibilities you had at the agency back then at the time? And I guess two-part question: would it have been unusual for workers' compensation to kind of come across your desk like this?
The workers' compensation piece would not have, because I think, as I said, we had the policy. If memory serves me, we had some folks in one of the divisions under the group that was dealing with workers' comp and a couple other, as I said, policy areas. So that piece wouldn't have been unusual. But at the time, we were dealing with implementation or continuing implementation of the hospital outpatient prospective payment system, which was implemented, I think July 2000, just the previous year. However, it was a pretty significant undertaking for hospitals and a vast array of other stakeholders. And so a lot of, at least my personal time, was focused around that system. The other piece that we were focusing on, I think, was the ambulance fee schedule. We were trying to move away from the way, we were changing the way ambulances services were paid for under Medicare at the time as well. And of course, we were at the beginning, if you will, of a transition to a new administration. And so, if you go backwards in history, President Bush was elected in November 2000, inaugurated January 2001. And I believe, while I think Tom Scully, who eventually became the Senate confirmed administrator, was probably in and around the building at the time, along with others, I don't think he had been confirmed yet. So there were still a lot of sort of transition related activities for us as civil servants to make sure that the new political leadership and policy folks coming in, were briefed on all the issues, what the major priorities were for the agency, et cetera. So those were, I think, some of the activities that were going on around the time that also consumed a lot of my time.
Gotcha. Do you recall, and I get it, like I said, I don't remember what I had for breakfast, can't expect you to recall the nuances of healthcare policy and procedure 20 years ago, but do you recall maybe other instances where you or your department were asked to interpret regulatory issues requiring the issuance of a policy memo like this? I guess what I'm getting at is was this unusual? Was this, looking at it now, is this like, oh, this is standard stuff we would do for the regional offices, or was this something special or extraordinary?
So, that's a good question. I don't, certainly all the major payment systems, those are implemented by what are now called Medicare administrative contractors, but they were called Part B carriers and Part A fiscal intermediaries. The instructions that were given to them were always done through program memorandum, which are official documents that outline the changes that are cataloged and sent out. And there's a whole cross-functional management committee that governed those for prioritization and other purposes. But at the same time, memos like this to the regional offices, I believe typically had gone out and probably still do. I'm thinking of some of the changes that occurred in what is now the Medicare Advantage program. It's called Medicare Plus Choice at the time. And particularly around, I think, 99, 2000, after some of the cuts that were made in the Balanced Budget Act of 97, some of the private plans were beginning to stop participating in Medicare Plus Choice. And, there were probably not, I don't know if there were policy or implementation. There were a lot of questions swirling around how the regional offices should be handling questions, et cetera. And so certainly giving guidance to regional offices through these types of memos, I don't think was unusual.
Okay.
So I guess that's kind of, my memory says, I recall memos like this going out to regional administrators. But if you ask me to find one somewhere, I'm not sure I could.
Gotcha. No, appreciate it. I mean, you were there at the time. Few of us have been, and you were in the thick of it. So I appreciate the as best as you can to recall it. So I'm going to go through kind of the evolution of MSAs, and then Mr. Patel, would love to kind of get your take on it. And obviously, this is your take as just a person, not of any agency or organization, but would love to kind of get your reaction, for lack of a better word, at what the memo that bears your namesake really spawned throughout an entire insurance industry, and really created a niche industry of its own of Medicare set aside. So just a few things of how it evolved. So obviously, since your memo, MSAs really just became a standard industry practice. Anytime a workers' compensation case is resolved, all the way down to individual jurisdictions adopting their own rules and codifying their own procedure of how these go. And you talk to any practicing workers' compensation defense or claimant's attorney, they're going to understand immediately what an MSA is, and they'll likely know what the Patel Memo was too. So there was also after it kind of became a cottage industry, this proliferation of MSA companies and vendors, even certifications such as the Medicare Set Aside certifications that we know, the MSCC and the CMSP certifications, as well as organizations such as the National Alliance of Medicare, the NAMSAP and the MARC Coalition. And it's quite amazing that this just niche industry really boomed from from the creation of this memo onward. And obviously it's open to interpretation. There's a lot of differing viewpoints on exactly what some of these, your memo and some of the subsequent memos meant. But I think this might be interesting to you, Parashar, is the establishment of a dedicated contractor, the Workers' Compensation Review Contractor, the WCRC, that reviews these proposals that are outlined in your memoranda, and I'll go through some of the review criteria. But this entity has been around for a while, and the current contractor goes by the name of Capital Bridge, and it was awarded a $60 million contract. So it can just show you the just by the dollars and cents, the gravity of what CMS has invested in to review these things. And they also set up the Work Comp Medicare Set Aside portal, which is a CMS developed web interface where individuals can scan in their Medicare Set Aside documents and have CMS review them. And maybe interestingly too, there were numerous memos after the Patel Memo that issued, at least a dozen or so throughout the years, that did things like establish the current review thresholds that we'll go through. A big change was in July of 2009, where there was a memo issued that required prescription drugs to be allocated. Before that, it was just services, chiropractic, outpatient, hospitalization for surgical procedures, but there was no prescription drugs that went along with it till July 2009. And then honestly, no discredit or disservice to your memo, CMS decided to sort of scrap the whole memo process. They would issue one here and there, sometimes a few times a year, and they decided to consolidate all the memoranda into a single policy guide in 2013 with the Workers' Compensation Medicare Set Aside reference guide. And it's now currently on version 3.1. They issued it this past May. And so they kind of replaced all of the policy guidance and Q&A sections that were included in your memo and the ones that led up to it. But almost all of the foundational framework is still contained in the WCMSA reference guide. So I don't know, Parashar, if you have any thoughts on just kind of what this industry came to be following your memo, or any reactions to it, surprise, shock?
Surprise, certainly. As I told you, I was a little surprised at what happened. But I will tell you, the fact that the basic framework is there, I think, is a testament to the folks like Fred Graybow. I think Paul Olenek was his manager, and others. As I said, I may have signed it. I'm sure I reviewed it and we had some questions, but it was, frankly, it's their thinking, their analysis, and their thought process about what makes sense given the regulatory and statutory framework that was in place at the time. Mm-hmm. What makes sense to make sure that CMS meets those obligations while, of course, balancing it with, practical implications in terms of implementation and how much information you can really collect and who you can collect it from. So hats off to those folks that actually put in that thinking. The fact that it's still relevant and still in place 20 years later.
Yeah, for sure. And kind of hold that thought about the regulatory interpretation, because on the last slide coming up, I'm going to go through a little bit more sort of kind of Medicare set aside framework. But on the last slide, there are potentially some proposed regulations, and I'd like to just get your thought as to whether or not CMS may better be served going at it a policy perspective or actually the rulemaking process. But in any event, components of an MSA, I won't belabor this. These are just kind of the basics. There's obviously the allocation, and this is the line item listing of services and prescription drugs and procedures that go into the MSA for the life of the claim. So that's the allocation component. Then there's the funding mechanism. How are you going to fund this thing? Are you going to fund it all up front in a lump sum, or are you going to structure the MSA? And then there's the method of administration. Okay, once you've settled the claim and you have your MSA, is it going to be left up to the individual claimant beneficiary to do it? Or are you going to hire a company? And this is what Ametros does, obviously. And CMS has indicated in the WCMSA reference guide that they highly recommend professional administration in MSAs. But those are the three components: the allocation, how you're going to fund it, and how you're going to administer it. And then how is the allocation derived? And this has sort of been a process that's changed a little bit over the years by way of CMS policy, but it's really, it's how it was done, back in the days of the Patel Memo. So it's a line item listing of services. That's the allocation. The last 2 years of medical and treatment records are utilized for it, along with the applicable pay history. So the medical, the RX run. Those are looked at. Any applicable legal documents. CMS typically does not evaluate any type of IME report at all for various reasons, given that there could be potential bias there. The drug pricing is at the Red Book AWP pricing, and CMS indicates that they're allocated on a case-by-case basis, and that's correct. There's a wide range of resources that are utilized and costing a particular allocation and a file. But what should be noted here too is that CMS typically adopts a conservative methodology. They're looking for a conservative methodology because they want to maximize protecting the Medicare Trust Fund. No one knows for certain what a particular individual will need. You can go based upon historical treatment records, but typically tie goes to CMS when there's a question on whether or not a particular item or services should be included in an MSA. And then we talked about review thresholds. Many of these are still to this day from the Patel Memo in there. Obviously, we have the Medicare beneficiary total settlement amount exceeding 25 grand, and we still have this reasonable expectation of Medicare enrollment that could include an individual who's 62.5 years of age or older. They've applied for SSDI, they've applied but been denied, and anticipate repealing the decision, et cetera, and the total settlement amounts greater than 250. Those review thresholds still, that framework from the Patel Memo still stands. And obviously there's a different submission process. It's a WCMSAP that's widely used that wasn't around at the time of the Patel Memo, but there's still development of a file if it's missing information. There's still the decision process where there's an approval or potentially a counter hire. And one thing that has changed from the Patel Memo, even though it indicated there'd be a ongoing review process post-settlement, is that I believe it was either 2008 or 2009, there was an MLN Matters that issued that indicated there'd be an MSP flag, a specific WCMSA flag that would be flagged in the common working file in instances where there was a submitted and approved MSA. So there could be potential coordination of benefits and denial of service if the MSA funds were not used and Medicare was billed. So that was a significant change from the Patel Memo. But I guess as we close here and kind of look a little bit to the future, and not to put you on the spot, but CMS has attempted throughout the years. They started the rulemaking process back in, I believe it was 2012, 2013, and it sort of went away. But we've been talking about workers' compensation almost this whole time, and specifically as it relates to the memo which bears your namesake, that's covering workers' compensation. But CMS has alluded to throughout the years that they feel they also have this right to have their interest protected in a general liability claim. And they dropped the rulemaking process on it 2012, 2013, 2014, but they brought it back in the fall of 2018 and have sort of kicked the can down the road. And I know you can't read it, so I've enlarged the copy here, but it says this proposal, and this is the abstract that showed up in on the website. This proposed rule would clarify existing Medicare secondary payer obligations associated with future medical items, so that goes to MSAs, and they list liability, self-insurance situations, no fault, and workers' comp. And it says specifically this rule would clarify that an individual or Medicare beneficiary has to satisfy this interest. And at the bottom it says this proposed rule would also remove obsolete regulations. And I'm pretty entrenched in this area and have followed it fairly closely. And I have no idea what CMS is going to do. They've changed the date on this since 2018. They keep moving it up. This month, actually, it's purported that we might see something. So I guess my question to you is, having the Patel Memo out there, which is policy guidance interpreting, a regulation, and obviously, Parashar, you're not speaking for CMS at all, but hindsight being what it is, having your memo out there, do you think the best way to approach this particular area would be to have it interpreted via policy, have the Patel Memo too that addresses liability MSAs, or should CMS maybe go through the rulemaking process to codify some policy?
So, my general stance on these things, back when I was at the agency and now that I'm outside, it's always good to go through notice and comment rulemaking, number one.
Yeah.
But at the same time, you can't write regulations in a way that they're always going to be able to answer all questions for the foreseeable future. As conditions change, right? And that's why you actually have policy guidance documents. And so I think in an ideal world, you'd want to see notice and comment rulemaking regulations get put in place. But for something this complex, you probably want to leave some room for guidance to provide sort of, exact clarifications, number one. And number two, there may be areas where the agency wants to say we're going to do some things almost as a routine matter of course, where you issue either a memo or guidance to the contractor. For example, if they were thinking of changing the limit, the $250,000 limit, and maybe indexing it, you could certainly put in an index, either an index as as deemed designated by the administrator or the secretary, or you can tie it to CPI or something. Of course, that'll mean each year somebody's got to issue a memo of what the actual rate is, right? And so that the memo process, if you will, probably has to exist in any case. I don't know why. Well, you can read we can all read the words here, right? Sure. They think there are some obsolete regulations and they want to clarify some of the current regulations, which is why they may propose to revise them. Whether that was done as cleanup or whether there were some court cases around it, as you said, I think earlier that, the memo created this industry, created this process. I think in the memo, we cite the underlying regulation. I'm not a lawyer, by the way, and so whether or not that's been sufficient for 20 years, is that why CMS wants to make a change? I don't know. We'll have to see the preamble once it comes out to get a sense of why CMS is proposing this.
Yeah. Well, irregardless, it's been fascinating. It was wonderful to find you, firstly, and it's been fascinating, talking with you and certainly talking with you here today. And you were a great sport to sit down with us. Almost 20 years later, and knowing you probably had so much on your plate at the time, and this was just one little part of, even though it's been many folks who are probably listening to this their entire life, for 5, 10, 20 years, for you, it was just probably a little snippet in time. But Parashar, I really appreciate you talking with us today, and I hope folks who are in attendance, obviously this is a pre-recorded webinar, so unfortunately you can't ask questions, but hopefully you enjoyed the talk we had here. And Parashar, again, sincere thanks, and appreciate it very much.
No problem, Shawn. Thank you very much. Thank you for the blast from the past, and certainly looking forward to your email once the proposed rule gets issued.
Sounds
Thank
good.
you.
Thanks again. Thank you.